Companies Act, Section 378(v), Meetings of the Board and Quorum Requirements for Producer Companies. Section 378(v) of the Companies Act, 2013, sets out the rules governing board meetings and quorum requirements for producer companies. This provision aims to ensure that the Board of Directors meets regularly, functions with adequate representation, and follows due procedure when transacting business. It also prescribes timelines, notice requirements, and penalties for non-compliance. 1. Frequency of board meetings. The law mandates that the Board of Directors of a producer company must meet regularly, specifically at least once in every 3 months, and a minimum of 4 meetings in each financial year. This ensures continuity of governance, active oversight, and timely decision-making. Regular board meetings are essential for monitoring the company's operations, reviewing financial performance, making strategic decisions, and ensuring regulatory compliance. This statutory minimum frequency prevents managerial complacency and ensures that the board remains consistently engaged in the affairs of the producer company. 2. Notice of board meetings. A written notice of every board meeting must be provided to every director currently residing in India, and every other director at their usual address in India. This ensures that all directors, regardless of their location, are informed about the upcoming meeting and can participate in its proceedings. The requirement for written communication emphasizes transparency and creates a record of communication, which may be essential for compliance, legal defense, or dispute resolution. 3. Responsibility for giving notice and penalty for non-compliance. The responsibility for issuing the notice of the board meeting lies with the chief executive of the producer company. Timeline. The chief executive is required to issue the notice at least 7 days before the date of the meeting. This advance notice period allows directors adequate time to prepare for the meeting, review relevant documents, and make travel arrangements, if required, for physical attendance. Penalty for failure to issue timely notice. If the chief executive fails to provide the notice as required, he shall be liable to a monetary penalty of 5,000 rupees. This provision emphasizes the seriousness of procedural compliance and holds the chief executive accountable for ensuring the smooth and lawful convening of board meetings. Proviso: shorter notice allowed. A board meeting may be called with shorter notice in urgent or exceptional circumstances. However, the reasons for such shorter notice must be formally recorded in writing by the board. This ensures that even in cases of urgency, the decision to shorten the notice period is transparent and documented, avoiding any misuse of the provision. 4. Quorum for board meetings. In order to conduct a valid board meeting, a quorum must be present. The required quorum is defined as 1/3 of the total number of directors, subject to a minimum of 3 directors. Explanation: if the total strength of the board is 9, the quorum is 3, i.e., 1/3. If the total strength is 7, the quorum must still be 3, since 1/3 would be less than 3. This minimum threshold ensures adequate representation and diversity of views in board decision-making. A meeting cannot proceed or pass binding resolutions unless the required quorum is met, thereby upholding the principles of collective decision-making and accountability. 5. Fees and allowances for attendance. Subject to the provisions of the Articles of Association, the directors, including co-opted directors, may be paid fees and allowances for attending board meetings. However, such fees and allowances must be approved by the members of the producer company in a general meeting. This ensures transparency and fairness in remuneration practices, member control over financial outflows related to governance expenses, and protection against excessive or arbitrary payments to directors. For more details, contact us.